What is actually scheduled for this afternoon is Elizabeth May Conway, file 241681. It's a resisting obstructing a police officer charge. It's alleged that on or about September 16th, he did resist or obstruct Detective Jason Oughton of the Sheriff's Department as a fourth habitual offender, making this punishable by, I believe, up to 15 years imprisonment. The prosecutor has agreed to dismiss that charge for a plea to attempting to resist or obstruct a police officer. Attempted resisting obstructing is a misdemeanor. It's punishable by up to a year in jail, fine of up to $2,000. I believe you've been in custody in that matter for 22 days. In addition to that, Mr. Truckee represents you on a number of other cases. Now let's talk about your other cases, Ms. Conway. You have 4 retail fraud charges pending, and you and I have discussed these, and we were close to resolving them until you realize if you pled not guilty, I'd have to let you out of jail. So you pled not guilty, and after 28 days, I let you out of jail. And then shortly after that, you got rearrested, and now you've been in jail for 22 days. These retail frauds, there's 5 of them. So of those 5 of those, the prosecutor has offered that if you plead to 1 retail fraud second degree, they would dismiss all of the other cases. So the plea offer, Ms. Conway, is you plead to 1 count of attempting to resist or obstruct a police officer, which is a misdemeanor punishable by up to a year in jail, a fine of up to $1,000.
Buckle up, guys. Today we are going to witness one of the most chaotic courtroom moments you've ever seen. Judge Middleton faces off with a woman charged with resisting arrest as a 4-time habitual offender, a felony that could land her 15 years in prison. But the surprises don't stop there. What follows is a train wreck of legal offers, personal defiance, and unraveling logic. Let's dive into it.
And 1 retail fraud, which will dismiss 3 or 2 other retail fraud second degrees. Are you willing to plead to those 2 misdemeanor offenses?
Not today. That's when I got crowbars. You guys arrested Cynthia lady, 2 hours dresser. I got beat with a crowbar during that case.
All right, well then there's another one. There's 2 more.
That's 3 of us, right? That's the 3 of us. And you guys arrested somebody on a possible abduction case. That was me. I was one walking around crutches.
Let's try another one. 842.
Can't do it. I remember getting beat with a crowbar and all that. And I was in the hospital a few times, and I got crowbar paperwork.
All right, this one was alleged to be March 18th at the Walmart store.
Crowbar.
In this one, on the video, you went out to general merchandise stores and you stole $264.88 of property. And they identified you from all the other thefts. And I think you went to Oakland County. Are you willing to plead to that one on March 18th?
No.
All right.
All right, guys, in this part, Judge Middleton tries to negotiate a deal involving multiple retail fraud charges against Elizabeth Conway. She's offered a reduced sentence if she pleads to just 1 charge, but instead of answering directly, she deflects with bizarre claims about being attacked with a crowbar and hospital visits. The judge keeps it together, but it's clear something isn't adding up, and she's not ready to take accountability.
Yeah, he keeps saying I'll get time served, but I mean, I'm not willing to be not let out of jail today and all that stuff. I'm not willing to transfer to nowhere. I got no warrants right now.
Right.
Try to keep it at that because if I were to be transferred today, it'd be very unfortunate because there's a couple of people that are supposed to have warrants for arrest today, and they still have been arrested. A couple of people have been following me to rooms, breaking into my motel room.
All right.
That's the main reason why I ended up back at my grandma's Bingaman.
All
So
right,
this
stop
lawyer
for,
just said some rude stuff about my Catherine Bingaman, my grandma.
all right,
tell me.
stop for a minute.
That's why I keep asking, hey, PR bond, PR bond.
I let you out on a PR bond, and 5 days later, you got arrested all over
Yeah, I
again.
had to call my family member Jason to start this, or
All right.
to Sheriff's County. But by the time I ended up going back to Constantine, Carlisle, because he was supposed to be there anyway, had called 911 for no reason.
All right,
And I got
Just-
smashed to the ground. All I
just-
got asked to was to leave and come back, and I couldn't because I had people break into my rooms. It's already supposed to be in jail right now.
all right, just stop for a minute. Mr. Marvin, I told you I was writing a comprehensive letter to community mental health regarding the cases that I see in custody that could greatly benefit from mental health services. Ms. Conway is one of them. Your lawyer's trying to get you out of jail. I don't know where you're gonna go. You got caught stealing 5 times in about a month. You were going to enter a plea to one of those charges on a plea agreement until you learned that if you pled not guilty, I'd have to let you out of jail on a 28-day rule. I'd give you a PR bond. So I let you out of jail, and those cases were not resolved. Once again, Mr. Marvin agreed to dismiss all the cases if you pled to one.
In this segment, things spiral fast. Conway rambles about conspiracies, people following her, breaking into her motel, even referencing family drama and cats. Judge Middleton tries to bring her back to reality but is visibly concerned. It becomes painfully clear that this isn't just a case of petty crime. The judge starts to mention something critical: mental health. And that's when this courtroom exchange takes a deeper, more serious turn.
They have you on video 5 times stealing stuff from the Walmart store. And then you have this new resisting and obstructing charge. The offer is to take a plea on the retail fraud charges, give you 28 days in jail, credit 28 days, and plea on the misdemeanor resisting and obstructing charge and get 22 days, credit 22 days, and let you out of jail. But I don't care if you stay in jail because A, you're not willing to admit that you keep stealing all this property, and B, I haven't worked out a plan on what to do with you when you get out of jail. You need some serious mental health treatment. And I was composing a letter to Community Mental Health this morning regarding you and about 8 other people at the jail that could greatly benefit from some services. So this is Mr. Marvin's plea offer: reduce the felony 4th bench habitual to a misdemeanor and let you out of jail, and dispose of at least 3 retail frauds and let you out of jail. But you have to admit that you did something wrong. I mentioned this the last time I saw you. I've watched you disintegrate before my eyes when you first came back to Constantine and you had a case down there. I've watched you dissipate, get sicker or worse. I don't know if it's methamphetamine or fentanyl or both or mental illness, but I'm watching you go downhill and it's not very pleasant to watch.
The emotional weight sets in now. Judge Middleton breaks down the full plea offer, credit for time served, reduced charges, and a path to freedom. But then he drops a gut punch. He's been watching her slowly disintegrate. Whether it's drugs or mental illness, he says, she's falling apart right before his eyes. This isn't just legal talk anymore. This is a judge genuinely wrestling with a human tragedy unfolding in real time.
So your lawyer, Mr. Truckee, tried to convince Mr. Marvin to let you get out of jail today. I don't have a plan. I guess I just lay out. I was working on a plan because you need one. So here's the deal. He will dismiss the habitual offender felony charge punishable by up to 15 years in prison if you plead to one misdemeanor count of resisting and obstructing. He will dismiss 2 other retail frauds that he has the authority to dismiss from Meijer or Walmart if you plead to 1. So if you'd like to do that, we can do it now. If you don't wish to do that, we can set these things for further hearing or a trial if we need to.
So, what are you trying to say?
So boy, I don't know if I can make it any clearer. I'm not sure you're competent.
I'm not sure all the cases behind my head because the Terry Kelly family, the Silent Waters, that Scott Bell have been arrested are behind here on the outside here. Because what they're trying to do is release of their bond of they put on me. But really, one of them raped me in June. So, and they're still not arrested, and they're looking for Saudi McWaters because he cut my umbilical cord out in September in a motel room out here. Why do you think I'm back in here?
Well, I think you're in here
I
because
think it's a legal attack that you guys are going to try and judge me behind their racist criticism. Because they were the ones who were tasing me outside the fucking motel rooms. I had to call my cousin Jason, my mom's cousin Jason Bingham.
Judge, I know nobody wants to be the one to raise competency of my client, but I don't think she can assist in her defense in this case at this point, based on what her statements.
I'm trying to tell you, I would rather prefer work on the first case that we're here for, because my other ones are supposed to be tried out until the 10th, right? What's today's date?
Here's where the courtroom starts to truly lose its footing. Conway begins an incoherent rant about a billboard, tarzing, and a strange conspiracy involving her family. Her own lawyer finally raises the big red flag, competency to stand trial. Meanwhile, she's still asking what she can plead to today, clearly not grasping the weight of what's going on. The courtroom energy shifts from tense to tragic.
yeah, they're set for a final pretrial. Well, we can do that.
Yeah, like today, what could I plead to right now?
Attempting to resist or obstruct a police
So
officer.
can I leave today if we plead today?
No, I'm going to leave you in jail if we resolve all the cases, but I'm not going to make you promises to try to get you to plead. I couldn't have explained it any more clearly than I did. All you're focused on is getting out of jail. I'm
Yeah,
focused
because your
on.
officers are in here in August tasing me while I'm laying there resting while
All
I'm
right,
pregnant.
well, they're not my officers. They're officers here for the county. They're in the executive branch. I'm in the
All right, so
judicial
I'm gonna
branch.
plead guilty to whatever you're saying to. And you're gonna take my plea deal, but I'm not gonna say anything further right now because I'm not gonna be disrespectful. But to remember this, do not threaten a Bingaman and talk shit about a Bingaman attorney. Don't talk about my Catherine Ray Bingaman like that again. And I mean it.
Oh, you're talking to me?
Yeah,
Liz?
when you were just out here, you said my grandma Bingaman's very rude. You don't even know her. How dare you?
Your Honor, I know that one of the ways to raise competency is by motion, and it's preferred, but at any time, I know I don't have the rule at my fingertips, but at any time during a proceeding, the court or any attorney for that matter can raise the issue.
Conway claims she'll plead guilty to everything, then launches into emotional outbursts, even lashing out at the judge over his comments about her grandmother. Her mental state becomes undeniably central to the discussion. The judge and lawyers now fully lean into the decision to pause everything and move toward a competency evaluation. It's clear, no court can proceed when reality and reason have left the room.
You agree with Mr. Truckee?
Yeah, and he already did, but I don't have a problem with that. I don't want her to feel compelled to do something.
All right.
And I don't like to raise this issue in these
Well,
cases.
I'm tempted to raise it myself. Miss Conway, we're going to have you evaluated for competency to see if you're competent to proceed and assist in your proceedings, whether you're able to
I wouldn't plead
understand.
guilty just to get out of here, but I'm gonna.
I-
make sure that
everybody
everybody's
would.
arrested
Somebody-
that's supposed to be. Most of the
okay.
people you break the house in the jail just because me and my big family members put them there. That's why you have people in here because they are ready for murder charges on the baby that's cut out of my stomach, or they attempt to murder me and hire gunsmiths to murder me, or my Bingaman family members. Do you understand what I'm saying now? So I'm going to plead guilty because I'm taking care of it because I'm on epileptic and medical medications, not psychiatry medications. So please don't talk to me like that. And when they disguise my paperwork at the hospital, it's because I was assaulted sexually or physically, and I don't want my assailants to attack me, which is all the people that Sheriff's own Marty should be in here, and all the people have been put in lives in here. So I'm taking plea deal right now, and I'm gonna make sure you guys take that plea deal. And I want to plead guilty to everything, but make sure, I hope you know when you go home and sleep at night, how dare you guys? And I'm pleading guilty. Please
All right.
take my plea deal.
I'm not taking your plea deal. You're going to be evaluated for competency. So please take Ms. Conway back. I'm going to have you examined for competency by the Center for Forensic Psychiatry. See if you're restorable or able to be competent. But I'm not comfortable taking the plea because I don't believe you're competent.
You mean you don't believe I'm
I'm
guilty is what you should say to me,
No,
sir.
I believe there's a highly likelihood that you're guilty, at least of some of this
No,
stuff.
I'm not actually. You're very
All right,
rude
well,
and you should lose your job.
the affidavits show you're on video
Lose
on
your
every one
job
of
is
these.
what you should do, Middleton. How
All
dare
right,
you?
bonds
Remember when you
remain the
called back
same.
to me last night? You were wrong. I put you up.
Judge Middleton brings it all to a head. He officially refuses her plea, ordering a psychiatric competency evaluation instead. Conway's final rant includes alarming claims of murder plots and conspiracies. Despite video evidence and a mountain of charges, Middleton won't take a plea from someone who clearly doesn't understand what's happening. And honestly, he made the right call. You can't punish someone who doesn't even comprehend the punishment. If you found this breakdown eye-opening, make sure to like the video and subscribe to the channel, and we'll see you in the next video.